Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Put them up.
Yeah. I ran the photocopying machine hot. I thought it would be easier when I'm speaking with you to actually have them in hard copy form.
It would probably help me to do that.
Yeah, so fascinating stuff.
Oh,
fascinating
absolutely.
stuff. I see that Scottish guy as being a bit of a smarty of late.
I'm sorry.
That Paul is being a bit of a smart ass of late. You know?
Yeah, on the last video he was. Because, you know,
Yeah.
I knew that I had been kind of beating on the control question, kind of repetitive about it. I was aware of this, you know, so that's why in the video, look, I'm not even going to talk about it. You guys know, I've said it 100 times, so I'm going to skip right past that. The Innocence Project's talking about how they were messing with the math, the figures of the math of wrongful convictions and false confessions and stuff. And I'm like, so this is now a second thing that they were misrepresenting. So
I don't think you can I don't think you can mention those things too many times. Seriously.
I know.
It's just that Scottish guy, you know, he hasn't got much to do up there, right?
So he comes in there. What exactly was it with the control question again? Thanks, Paul. Thanks, Paul.
Yeah. He'll laugh his head off.
Oh my Lord. Yeah, he's a hoot.
Indeed. So how would you like to start? How would you?
Well, we kind of already have.
Okay. All right. Well, maybe I could say a few things generally at the beginning in reviewing the amicus briefs, and then we can perhaps then delve down into individual briefs and talk about those.
Yes, sorry. There we go. Okay.
Is that a bit of a strategy?
Absolutely. I mean, I've done 6 videos, and I've done a hell of a lot of talking about them. So I'm willing to let you talk, and I can just throw in some of my own thoughts here and there.
Well, I think the Department of Law at the University of Sydney is going to issue you with an honorary law degree after all this is said and done. I mean, your work in getting into the depth of this is just breathtaking. So,
you know, I mean, but I gotta say, it's a community thing, though. I'm obviously part of the community, an intense community of people that have hung around this long. You know what I mean? But I'm part of that community, and there's a lot of things that everybody brings to the table. You know, very, you know, various different people find different things as they're looking through the paperwork and all that kind of stuff. And yeah, I mean, it's not just me, but yeah, certainly I'm paying attention. I'm doing my own digging, and when I see other pieces of information that can help an argument or something that I've discovered that I thought was odd, that I think the two things can go together, I'm, you know, always quick to appreciate, you know, that other side, you know, that person on the other side of the table that came up with that bit. And that's what I think is great about the MAM community, because everybody's out there just, you know, going through this massive amount of stuff and absorbing it and kind of seeing things that they didn't see the first times they went through. Because the first times they went through, they didn't have enough, they didn't know a whole lot. They were really just getting to understand the case. So they didn't understand a lot of the interpersonal connections between people and things like that. But as they go through now, and they know a lot of those things, more things begin to make sense. And, you know, so.
Yeah, there's some interesting aspects of this whole case with Stephen and Brendan and, if you like, the legal process that's unfolded. One of the things that comes to mind is the fact that the documentary came out approximately, let's see, 8 years or so after both the guys were convicted. Made me wonder if it had come out, even though it couldn't have, because it carried a lot of other issues post-conviction. But if it had come out a lot earlier, would it have been as powerful in terms of the impact? Because so much more is known now, 10 years down the track, about wrongful convictions, about DNA evidence, about the whole criminal justice flaws, that notwithstanding no one would want Stephen and Brendan in jail longer than, well, at all, let alone any length of time. The fact that it's taken this long has probably allowed the whole issue to blossom into something more powerful than it might have otherwise been.
Well, yeah, the more that the state of Wisconsin sits there going, nope, nothing happened, making a murder is crazy, you know. Like I said, I compare it to if you've ever seen the Naked Gun movies, there's one where a car crashes into a fireworks factory. Leslie Nielsen gets down there, and he's standing there, and he's waving his arms. Nothing to see here, folks. And fireworks are flying into the air and going off, and nothing to see. That's what Manitowoc, that's what Wisconsin's like. They're like Leslie Nielsen standing out there going, nothing to see here, folks. Nothing to see here. I mean, that's what it reminds me of. I mean, comically, that's what it makes me think of, you know, sometimes, because that's what it's like. It's like the fireworks are going off, guys. Turn around. Tell us why that's happening.
Exactly. And the other thing that follows in the same vein is the fact that this has had a pathway that now has got it, in the case of Brendan's case, it's now got it to the Supreme Court of the United States. That
potentially on the
suddenly,
threshold.
Yeah, well, at least it's being considered.
Yeah.
Then all these other minds
certainly going to help.
All these other minds have come into the debate, or at least the public debate, that we might not have otherwise seen. And it's in many ways, reading the briefs and reading the arguments in the kind of the application from Brendan's lawyers, and then all the amicus briefs, made me kind of restored my faith a bit, quite a lot, that we've got such a pool of quality minds at this level of the justice system that we may not have seen had it been dealt with in lower courts. Now, if it had been dealt with in lower courts properly...
Certainly not on the scale we saw it here.
Yes.
But yes, certainly. I mean, yeah. And I think there's a few people that sent in amicus briefs that I kind of really haven't heard weigh in on it yet. So I think certainly we got a few opinions in the amicus briefs that I hadn't previously heard. But I had heard like representatives from like 4 of them in the Brendan Dassey, A True Story of a False Confession, the YouTube video that I posted on Facebook the other night. The psychological and psychiatric union was represented by I forget her name. She was up there on the stage in between Robert Meelan and Laura Nyrider. You obviously had Robert Meelan there as a former prosecutor, so I'm in my mind I'm convinced that Robert Meelan was part of that amicus brief. Right. So
I'm sure.
And so I've seen some of these organizations represented by like a single person talking about the fundamental principles of what those organizations believe, but like I never had really heard much from the Juvenile Law Center before about this. Had heard from the law professors in the previous amicus brief and the law enforcement trainers in the previous amicus brief that went to the 7th Circuit. But yeah, and then the Innocence Project's amicus brief was quite interesting. In fact, that one I thought was probably not going to be as great. I actually left it for last because I didn't know how good it was going to be. But that one ended up getting me the most fired up.
No, what a
the
classic.
end of that video, I'm just like, but
I couldn't help but grab onto a thought you'd made when you were commenting, both in the past and then about the whole issue of Ken Kratt's heartbeat going up a 30 or 40 beats per minute more, right? When Judge Willis had talked about the deleted phone messages, and I'm thinking, your heartbeat's going up 30 or 40 beats a minute more in the delivery of your soapbox oratory. So, which was fantastic. Yeah. So.
All right. All right. So yes, as I was saying, yeah, the Innocence Project's amicus brief ended up getting me pretty fired up, compared
Indeed.
to the others. So yeah.
And
And
the other general thing I wanted to say before we go into any specifics is it became really clear to me after the first two briefs is how poorly the law at the Supreme Court level is, if you like, sustained and interpreted downstream in the lower courts.
right.
And by virtue of that, the lack of quality control downstream. So
Yeah.
I'm sure it comes up in some of the briefs indirectly in some of the comments that are being said
Oh,
how,
I think that they're
oh,
yeah. I think one of the briefs is hammering on that pretty much as one of its main
yeah,
points. But
yes.
yeah, certainly.
And therein lies some sort of lesson, if you like, or some message about, what, whether the Supreme Court, it may well have this, whether it has a quality control process to pick cases that have been determined and bring them back to themselves, not for determination, but for quality control,
Yeah.
to see whether the lower courts, especially the senior lower courts, are properly interpreting and carrying out what is their law. So
Right. Yeah.
that was pretty evident to me.
Yeah.
So,
I mean, certainly that was certainly like a huge point in the law enforcement trainers brief. They were
yes,
they were very much about that. About how the practices that are being practiced are not in accordance with the precedent that has been set forth by the Supreme Court. The Supreme Court has
yes,
multiple times shown, and they show throughout the amicus briefs, you see so many different instances where the Supreme Court has said that juveniles require special care. You just wonder how there isn't already, by now, in like across the United States, already like methods of how you interrogate a juvenile instead of as opposed to interrogating an adult. And the fact that this is an issue that it's having to be dealt with still, I don't know. I mean, it seems pretty obvious that children and juveniles are not equipped to deal with the kind of adult situation that a murder interrogation is. They're not. They don't have
they're not
any of
equipped.
the skills. They haven't developed any of the social tools that that they need to kind of help them deal with that situation and hold their own. I mean, that's just a
Well,
no-brainer.
well, young people. I mean, I've got children. They're all of young adult age these at the moment. But I mean, young people aren't equipped to deal with positive things in life, let alone negative things like being in police custody or police interrogation. I mean, they struggle, spending the money in the right place or whatever,
Right.
or drinking too much or whatever. I mean,
Right.
that's just the developmental aspect of a young brain,
Yeah.
and so to think that they'd be any more equipped when dealing in what's almost adversarial environment of being interviewed or questioned by police is just beggars
With the
belief.
white
That's
hot
just not how.
spotlight. Yeah, absolutely.
Correct.
Yeah. I
Yes.
mean, of course they're going to be, and with them, the thing I love about these amicus briefs and the things they kept talking about is when you take all the aspects of what these officers did, when you take the friendly manner where they were basically endearing themselves to Brendan, like, oh, but we're fathers right now, and I want to come over and give you a hug, and you don't need to worry. We think you're okay. That a lot, right? And then getting into basically where they're getting towards the point of promises of leniency, which is another no. That's no number
Yes.
two. And then
Yes, that's a
you get beyond that. Then you get to the fact that there was something else, and then add on top of all of it, on top of the whole Sunday, the whole poop Sunday there, you just sprinkle on the fact feeding on top, the little poop sprinkles on top of the poop Sunday. That's what the fact feeding is, because it just adds to the It just adds to the number one. It makes the confession lose credibility, because if none of the facts came from the person being interrogated and it was fed to him, how can we be sure where this came from? Did it come from you guys, the investigators, or did it come from him? I mean, it's at that point, it's an honest question, because if the facts are fed, how do we know?
Yes.
So,
and as you say, in that amicus brief, I'm just looking down at it from the independent law enforcement instructors and consultants. They specifically say in that brief, in respect to Brendan's specific circumstances, that the interviewers should have known not to do the things that they were doing. So they acted willfully in their conduct with Brendan, that they would have known that that was the wrong thing.
Particularly when he actually tells them, I was guessing. When he talks about the hair cutting, he's like, why'd you tell us that? I was guessing.
Yes.
I mean,
and a point you mentioned in many of your videos in regard to the question of when Mark Wiegert finally in frustration says, well, in regard to the head thing, you know.
Yes. Who shot her in the head?
Well, who shot her? And he said he did. And then Fassbender said, why didn't you tell us that? He said, I couldn't think of it, right, as you're quite right. Now, that word couldn't is so important because it suggests he was trying to think of it.
Yes.
He didn't say, I didn't think of it, which means you have a prior knowledge and couldn't remember it.
Right.
By him saying he couldn't think of it, he said it just couldn't come up with the answer you wanted me to come up with.
Yes, to word it that way. See, it's just kind of, when you learn how we over here speak as Americans, that's like a common turn of phrase right there.
Yeah.
And so that's what that generally means when you say I couldn't think of it, you're basically telling somebody I couldn't guess what you wanted. Yeah. Whereas if you couldn't remember it, you would say I couldn't remember or whatever, you know? But see, that's why I think his wording of I couldn't think of it just totally tells the tattletales on the fact that he was guessing, you know, and he's, you know, so.
And I mean, and all the surrounding commentary that was before and after that shows you that he was guessing, and that of itself should have been just a straight out flag to say, hey, this is something that we can't rely upon.
Right.
But I mean, their intent wasn't the intent in the interest of anyone other than their primary goal of getting somebody, in this case Brendan, to be state's witness or state's evidence against Stephen Avery.
When you think about it, and anybody out there listening right now, when you think about it, they had a whole weekend with Brendan, people, and his brothers, but they had a whole weekend. A whole damn weekend. You're going to try and tell me that after Friday, after Saturday, Sunday, and then that whole interrogation on Monday, and then eventually have Brendan tell them right to their face, I was guessing?
Yeah.
And they still moved forward with this and thought that it was a good confession. That tells you. It tells you right there. You know,
and in this brief, it's coming from the very people who trained them.
One other little aspect to that. To suggest that they didn't see Brendan's limitations in all that time that they spent with him in those 4 days is also laughably ridiculous. Sorry, go ahead.
Yeah. Well, they knew of his limitations the first time they interviewed him.
Absolutely, they did. But
back in November, let alone when they got him out of school and they interviewed him at the school. They would have known his limitations straight away. But, you know, one of the things that follows from not just this particular issue, but from a whole range of issues in these cases is the issue of how do we help prevent this from happening in the future? And I'll come a little later on to the issue of reform, but something while we're on this topic is I believe that when someone is being interviewed, so let's just for the sake of line in the sand call it under 21, that they should be signing, that is the police officers or the sheriff's officers or detectives or whomever should be signing a representation statement outlining, and that statement should be set by the Supreme Court, outlining that they followed the Supreme Court mandate about special care provisions. I did this, I did that, I did this, I did that, and they have to sign it to get them on the hook for professional conduct. They have to behave professionally.
I'm thinking that is probably going to be something like the Supreme Court's going to have to do. They're going to have to say, you know, from now on, okay, in order to give special care, you have to actually consider these things in the decision. And there's going to be a list. There will be like a list of
sign
things,
for them.
You know,
and sign off on it, because it puts them on the hook that they actually declared I did these things, and if they didn't, well, then that would be,
Right.
a breach of their professional conduct
Well,
and
that's
potentially contempt of court,
the
right?
whole idea of making them put it in their decision, because the decision is signed by them. It's their decision.
Correct.
So
Yes.
absolutely, that will be the whole goal of the Supreme Court now, making judges and courts put that weighing in. Show us your
Yes.
work. How did you do this? How did you weigh it? What? How? And I'm sure the Supreme Court will make a rule like, and even if it's slightly flawed, as long as it's mostly reasonable, then it will stand. You know what I mean? It'll probably have some caveat like that, but at least it'll be a place where people can look at and go, wait, was this kid really given special care? Can we really say that happened here? And you can look over how they weighed it, what they weighed, if they actually, if there was anything they missed, and whatnot. So yeah, I certainly think that's hopefully one thing that the Supreme Court will do is to say, in the future with juveniles, you need to state, we did the totality of circumstances test. This is how we weighed it, blah 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 blah, and this is how we came to our conclusion. I think it needs to at this point, because the epidemic with juveniles giving false confessions is ridiculous.
Yes, and I think it was either in the first or the second amicus brief that you reviewed, when it was referring to the issue of special care. In the discussion on special care was the question about whether the form that special care should take. In other words, in respect to Brendan's case, they were saying that, well, okay, at the federal court level, at the en banc level, the en banc panel said, okay, they referred to Brendan's age, etc., but they didn't conduct a proper review of the special care requirements. They were arguing.
They basically accepted the appeals court's, evaluation. Go ahead.
Yeah. So, to me, the point that came home there was that special care is not just being mindful of it; it's actually doing something. It's not just, oh, I'm aware that he has intellectual disabilities. I'm aware that he's young. That's not good enough.
I'm aware
Everyone's
that some
aware
of these
that
tactics were questionable in regards to minors or juveniles. I'm aware of this. I'm aware of that. I'm all blah 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 blah. Oh, but they never touched him or hit him or anything, so none of that matters. That's basically the way that they see it, right? One of the great quotes that I thought was in there from the Supreme Court was this: "The blood of the suspect is not the only hallmark of an unconstitutional inquisition." And I mean, I think that's brilliant. That is a quote from the Supreme Court itself in a past decision, meaning the blood of the suspect, namely in this case Brendan, is not the only hallmark of an unconstitutional inquisition. That it can happen. You can be coerced by psychological means, and not just by being beaten.
Of course.
So.
And the other thing that was emphasised in the psychologists and psychiatrists and social workers amicus brief was they make this statement. They say false confessions are highly likely to be involuntary. So in other words, people don't knowingly make false confessions. This is a really important point.
Yeah.
False confessions are highly likely to be involuntary by their very nature. So it goes to the heart question of, why did people falsely confess? Well, they falsely confess because they don't realise they're confessing. So they're involuntary confessions.
Yeah.
So.
Yeah. Sometimes they do, though. It's, I don't know. A lot of times it happens because the person's just been, look at Melissa Caluzinski, for instance. I don't know if you've heard about that, but she's one of Zellner's clients as well. But what they did to her is wore her down. She resisted them for hours and hours and hours, and she was like, no, I didn't do this. I didn't do this. I didn't do this. I didn't do this. And blah, 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 blah. And then eventually they started, trying to be buddy-buddy with her and this and that, and started telling her, oh, come on, don't worry about it. It was just something small, right? It was accidental. It was an accident. You dropped the baby, right? Or something, whatever. And they end up getting her to just say something because, and they get her believing through whatever trickery that if she did, she'll be able to get out of there, which is what she wanted. That was what she wanted. And so,
Yes.
in order for her mind to get out of there, which is what she so desperately wanted, she gave them this BS story that they had already kind of given her the bones to, as it were, already. They already kind of sketched it out for her already. So, yeah, how do you take that one seriously? But especially when you know she was resisting for many hours, telling
Correct.
the same story for many, many hours. And it was only until she saw a glimmer of hope to get out of there that she suddenly changed her story in the hope that she would get out of there, and found out that that was actually tightening the noose around her neck.
Yeah, and there was that fellow. I'm sorry, I don't remember the name of the case or the gentleman who it was on a Netflix series called.
Yeah, Melissa Caluzinski.
Yes. Well, there was a different one.
It's a girl. She was a healthcare. I'm sorry. She was like a nursery home worker, and there was a baby that ended up having a head injury that died, and they ended up trying to pin it on her, but it turns out the baby was actually known for, you know, falling and playing hard and ended up hitting his head a lot, and he had previous head injuries that, you know, so there's a whole lot of stuff around in that's wonky in the case. Her original attorneys were not sent proper x-rays of the baby's head. The x-rays that were sent to them were all blacked out, and they didn't know how to fix it, and they couldn't find anybody that did, because nobody at that time could get it on Photoshop and change the color aspects and make it appear again.
Oh, right, yeah.
Somebody had deliberately blacked it out, like in a Photoshop type program, so that the defense couldn't really see it. So that was for her original trial. So there's a lot of wonky stuff. You know, whenever you can follow the trail of wonky crap happening, you can usually bet there's a wrongful conviction right behind it. You know,
which nicely leads to an issue. I did a video. I think it might have in fact been the last video I did about criminal justice reform, and my opinion is that confessions of themselves, whether they're false or otherwise, confessions of themselves shouldn't be regarded as adequate evidence of anything. In other words, for someone to be convicted, there should be some other evidence that gives validity to that confession.
Yes.
There's something to corroborate a confession.
Corroboration, yes. There should be some.
Yes.
At least.
Because we have this bizarre thing with Brendan, which we've mentioned before, where he has these so-called confessions, which are born out of coercion and other activities of the investigators. Brendan goes into court, right, under the pressure of a court environment, a judge, a jury, the prosecution, and he recants that confession. Right. But in court, recanting your confession is not as valid as what you said outside of court with no one there to support you and in a coerced environment. Right. It's like anything they gather outside the court has greater weight than your own statements inside court in the evidence of the public, of the jury, the judge, and everyone.
Yes.
But that to me is just the wrong weighting of what
Brendan's statements in court mean less than his statements that were
outside of court.
Right. Extracted from him somewhat painfully out of court.
Yes.
Right. Absolutely. I agree with you. I liked that video, by the way.
So to me, you have to have corroborating evidence for a confession to be held valid. That's my view.
It seems like that's the way it should be, but sometimes they're so desperate to get somebody for it that.
Well, this should be all about reform, in my opinion.
Well,
we don't. If we don't get a better criminal justice system out of this, and we get Stephen and Brendan free and others, that will be great, but it won't be the true prize. The prize will be the reform.
Yeah.
So.
The fundamental change in the way that we see, the way things work, because clearly DNA is teaching us, and it's inevitable. It's going to happen one way or another, but DNA is teaching us that we're getting it wrong a significant percentage of the time. So we need to acknowledge that. We need to take that into account, especially in terms of that stat from the Innocence Project. Did you see it in my video where it said?
Oh yeah, about the number.
With mentally impaired individuals that 70%. Had been exonerated, 71% had given a false confession. 70. That's 7 out of 10 of them. had given a false
Yeah.
confession. I mean, what does that tell you? You know, I mean, that says it all right there in my mind. You know, so yeah.
But
How
therein
can you
lies,
ignore that?
if a confession is false, if you follow the logic of this, if a confession is false, there will be no evidence to support it.
Right,
Correct?
right.
Because it's
It'll seem
false.
silly or
Right.
ridiculous. Like,
And
well, kind of like
and there
Brendan's does.
and the red flag should be, okay, Brendan or Bill or Bob or John have confessed.
Yeah.
Where's the evidence to support the confession? If there is none, that should be the big red flag structurally, just not in the emotion of the prosecutor or the investigator.
Sirens
Should be,
and lights
we
should
have
be
no
going off.
evidence.
Sirens
We
and
have
lights
no
should be going
evidence to
off.
support the confession. And therefore, if the law was to say, in the absence of any meaningful corroborating evidence, a confession can't be held to be valid on its own, and that should be an instruction. Or either not entered as evidence, probably would be the best thing, if it can't be corroborated. But even if it was entered, that some sort of instruction to the jury or whomever to say, we don't hold this as being adequate evidence all on its own.
I would think with some weighing of the circumstances of the confession, I guess.
Yeah.
I would say.
Look,
I would say
70% of
if it was a confession that had to be dragged out over hours, then yes, definitely. If it was a confession that you just walked up, caught the guy, and he just blurted it all out to you without you even asking him a single question, I think we can enter that into evidence. Pretty much the way it is, in my opinion.
I don't have a problem with it. You probably could do that. The question is, what if he's lying?
Well, I still think it should be weighed against actual evidence, of course. You know, but when I say you pull up and, like, I'm talking about you're catching him practically with red-handed, as it were. You know.
Yeah, correct. Yeah, and if that law was present in Brendan's case, he wouldn't be in jail.
I think they should at least. Yeah, I mean, there should be some aspect of their story. Well, should be a significant portion of their story that fits the actual known facts of the case. That should go without saying, without it being fed to the suspect. So.
Correct. So that if you take those two levels of reform, that is the issue about the investigators have to say that they followed the special circumstances thing, right? You've got the video and
a new method for interrogating juveniles, basically. Yeah.
Yes, you've got video and audio evidence to show the methodology adopted, and the confession. If a confession arises out of that, I'll come to another aspect of that in a moment. But if a confession arises out of that, that confession has to have some reasonable weight in evidence to give corroborating support to it.
Sure.
And to me, a confession. I mean, one of the other reform things is that if you're under age 21, a confession is not valid unless it's given in the presence of legal representation and signed for in the presence of legal representation.
I don't think in every state. I think not in every state.
No, that's what I think it should be. I'm not saying what
certainly.
it is.
I think it's, yeah. I think
what it should be.
I think that all juveniles, yes, should have at least some advocate. And I think maybe it should be an independent advocate, maybe not always parents, because parents will allow their emotions to
and they don't know the law either.
Right. So an advocate might be the best thing, to where all counties and everybody have a handful of advocates that are on hand for the situations when they have juveniles coming through that they need to help, or whatever. So I don't know, that's what I think anyway. So we certainly need to think about that, because we can't, like these briefs were saying, we cannot just go ahead and apply the read technique in its raw form without any kind of adjustments right onto a juvenile. We can't do that. Even the Supreme Court has said in previous decisions you can't do that. If you do that, you're going to make the confessions severely questionable. You're gonna make its validity questionable. So I mean, and the Supreme Court has said that. So, I mean, the fact that it isn't being done still, I mean, yeah, that's what I'm, that's why these things are just hammering it home that they need the Supreme Court to just kind of put its foot down here and kind of just crack the whip, as it were, and get everybody in line and say, look, this is crazy. You can't be doing this. The Reed technique was designed for adult suspects. We know, the numbers tell us, everything that's DNA, everything's showing us, the social research is showing us that the juveniles, especially the mentally, impaired ones, are falsely confessing to crimes all over the damn place. You got to take that into account, knuckleheads.
Correct.
So